guys. Thank you all for being here today. I'm really glad to be speaking at Digital Dragons 2022 and to talk to you about one of the most important legal tools in the games industry, which is the publishing agreement. First of all, let me present myself to you. My name is Andre. I'm a lawyer and I have been working with the games industry for the past 10 years now. On my professional activities, I work mostly with indie studios, some publishers, some investors, and I offer legal assistance in transactions and litigations related to this market, as well as to other related markets such as esports and some IT segments. As you guys certainly know, the game industry is an ecosystem that's extremely internationalized, and therefore it has its own dynamics. And that's something that also reflects in the way that legal issues are addressed in this market. The game industry is a place that combines different legal areas such as intellectual property, corporate law, tax law, entertainment law, and also different legal traditions that almost end up creating a law of its own, a law that regulates the relationships in this market. And when we talk about relationships in the games industry, we must talk about publishing agreements, a legal instrument widely used to regulate deals made between developers and publishers. My objective today is to give you a brief notion of this kind of agreement and to call your attention to a few important topics that should always be considered when designing such documents. Whether you are a game studio, a publisher, an investor, or any other professional that might face a publishing agreement in your journey, I believe that this topic will help you today. First, as a good lawyer that I am, I should make a disclaimer here. So please bear in mind that the opinions that I express here are my own and not from my law firm or from any other entity. Also, the explanations I'll give during this presentation are not to be considered as a legal advice. If you have any legal doubts for your specific situation, please contact a lawyer. Our starting point today is obviously establishing what is this contract, what is a publishing agreement. I believe that most of you, especially those who are in this market for a certain time, have already seen, signed, or even proposed a publishing agreement. Maybe the name of the contract was not exactly this, but the name is what matters less. It's the nature of the agreement relies on its clauses, on the duties and obligations that are described therein. In this sense, you might have seen a publishing agreement, a development agreement, a business partnership agreement, in which the contracting parties agreed on delivering and commercializing a game while they shared the revenue arising out of this common project. This is the essence, the nature of a publishing agreement. In this sense, publishing agreements are contracts celebrated by two or more parties, companies and sometimes individuals, for the exploitation of a project of common interest for a determined period through which the contracting parties commit to deliver something, whether it is an intellectual property, a game, money, services, know-how, and etc. In return, parties share the profits thus generated. Usually, these agreements are celebrated between a developer, a game studio, and a publisher, a company dedicated to market and distribute games. Therefore, in general, developers commit to deliver a game and its IP, while publishers undertake to perform commercialization activities. Take the recent example of Raw Fury. This publisher has disclosed its development and publishing agreement template for the whole community to consult, which was a pretty nice gesture from their part. But if you take a close look at it, and you see that this is a traditional publishing agreement template as the one I explained to you before. Nonetheless, it is also common to find other kind of negotiations and players as a part of a publishing agreement. Services like sound design, localization, and also the licensing of IP for game adaptation. In these cases, the contract might receive names such as co-development agreement or business partnership agreement, but it will certainly have a publishing agreement essence structure in its core obligations. Although such a structure seems an easy thing to imagine and to create, relationships are always complex to regulate, especially in this industry in which players are usually from different countries with different cultures and obviously with different legal traditions. In this sense, it's really important for us to know what kind of activities and services could be a part of a publishing agreement. Well, let's start with the game studio. The ultimate obligation of this player is obviously delivering a game to this project, to the common project. Sometimes the game is already finished, while in other situations a publishing agreement is signed when the developer has only an idea or a prototype of its game. In the latter, considering that this is the ultimate obligation of the game studio, parties should always or should at least consider defining dates, deliverables, as well as situations in which delays might be. For example, if there is any change regarding the requirements to publish a game in a specific platform or country. Following the development obligations, we might also find other related activities, such as porting, localization, and sound design, for which it is also important to establish conditions for its delivery. Sometimes the game studio commits to perform such activities, whether by itself or through other service providers. Sometimes a party of the publishing agreement is the one responsible for that. Frequently, publishers will bear the costs and hire service providers to perform these activities if they were not provided yet by the game studio. And in this case, such costs will be certainly included in the recoupable amount, which we will see later on. Sorry. When game studios are not responsible for such collateral development activities, as I like to call them, it is highly recommended to include a clause in which the studio has the right to inspect and supervise the execution of such services, since they will certainly impact directly in the quality of the game. Now, let's take a look at the ultimate obligation of the publisher, the commercialization, which includes distribution and marketing activities. The know-how and the network that publishers have for such purposes are the main assets they deliver for the project. Initially, it's almost contradictory to imagine that it's necessary to define selling obligations for a company that has a share in the revenue of a game, but sometimes this could be helpful. As I see it, it's important to establish some milestones for the commercialization activities, such as an official launching date after the delivery of the Gold Master, the commitment to take launching events, to produce content in social media, to invest a minimum amount of money in marketing. Well, I think you get the idea. And still in this topic, parties of a publishing agreement can also establish some rules for the commercialization rights, such as defining in which platforms the game should be published, a capped price for its sales, in which territory sales shall occur, and so on. In more advanced agreements, game studios can also propose sales goals to be performed by the publisher. And if such goals are not met, publishers can lose its exclusivity or have its revenue share percentage reduced, for example. This is mostly seen in agreements of games that already have a certain prestige in the market. And last but not least, we should talk about money. Usually, in cases where the game is not finished yet, or when the game studio does not have the required funding to market its project, publishers will take the financing role in this activity, in this contract. In the indie games industry, this is pretty common. But it's really important to take a close look on how this financing is structured in the agreement. When the deal includes an intense development phase, payments will usually be made in installments, triggered by the delivery goals achieved by the developer. If the game is not delivered, usually publishers take two different approaches. All money paid in advance shall be returned, which is most common, or the creations and the intellectual property of what was developed until that termination moment until the termination of the agreement shall be assigned to the publisher. Finally, parties should also think about the payment logistics. Considering that publishing agreements usually have parties from different countries, you should consider where payments shall be made, which taxes are due and by whom, and what documents are required for such transactions. In some countries and in some payment platforms, before receiving money from a transaction, you usually need to present a document to justify such operation. In several countries, including US, Brazil, and many European countries, tax authorities demand its nationals to withhold taxes, usually something from 15 to 30%, on payments made to foreign companies or individuals related to royalties or to development services. Another relevant topic in a publishing agreement is the intellectual property one. Talking about the game itself, in the great majority of cases, the intellectual property is and will remain owned by the game studio that created it. In this context, game studios will grant a publisher a license to distribute and commercialize the game that contains such IP. Such license is usually temporary during the term of the agreement and paid with a revenue sharing system that we'll discuss later. Parties should pay attention to the extension of such license. If they include only the right to sell the game, to produce and sell ancillary products such as toys, downloadable content, soundtrack albums, etc., or even the right to sub-license such IP. Even the license to sell only the game can be limited in different ways. Only for a PC platform, for example, or only for a specific territory. In a few countries, usually those that follow a French tradition in their copyright laws, business that include the licensing of copyrights should always be interpreted in favor of the creators. Therefore, publishers should also take a closer look on how the licensing terms are defined. Usually, in publishing agreements, you find a standard clause declaring that any right not expressly granted in the agreement is reserved to the developer. For every party of a publishing agreement, I strongly recommend making a previous clearance review. In other words, to identify all the IP assets in the project and confirm that the parties of the agreement have the required rights to use it. Again, as you guys know better than me, is a myriad of creations. Therefore, if one of such elements is not authorized to be there, this could jeopardize the whole project. Besides that, every party in the agreement could be considered jointly liable for any infringement in this regard, especially developers and publishers. In Brazil, we had recently multiple lawsuits filed against publishers of football games because of the lack of licensing in regard to the players' image rights. Although this is not intellectual property, it's something pretty close related. In the origin of these lawsuits relies negotiations made between publishers and entities that supposedly had the authorization to sublicense players' image rights. For now, publishers have been losing the lawsuits and paying players and players' associations for such unauthorized use. In this other case that you can see here, a photographer filed a lawsuit against Capcom, claiming that such company used part of her photographs in some items of the game, and therefore claimed a $12 million compensation for the damages caused. Here you can see the comparison schedules presented in the lawsuit, which seem to be pretty similar, actually. And what's interesting in this case is that the plaintiff, the photographer, became aware of this supposed unauthorized use of its photographs after discovering that a few files kept by Capcom had the same name of the files contained in the CD-ROM that was sold with her photograph books. And that happened after the data leak of Capcom in 2020, as I recall. According to the media, parties settled in an agreement and the lawsuit was ended. But you can take a better look at the lawsuit in the QR code that I put it here, and you can make your own judgment in this regard. But what matters is that it's because of situations like this that you always find, or at least you should, find a clause in your publishing agreements in which parties guarantee that the contribution they made to the project will not infringe upon third-party rights. Otherwise, the agreement could be terminated, and the party that infringed it would have to compensate or reimburse other parties for the damage and losses they suffered. In rare cases, some agreements will contemplate an IP assignment, not a license. In other words, the intellectual property owner will definitively transfer its rights, in total or partially, to the party that usually is paying for such assignment. When talking about adapting other creations like books or movies to gaming projects, the assignment of IP rights is mostly common. But even in these cases, problems could and can arise. I'm pretty sure that you guys, especially here in Digital Dragons, know about this case. But it's really important to bring it as an example here. 3 years ago, I guess, the author of the Witcher book initiated a dispute against the publisher of such game, claiming that he was underpaid for the assignment of his IP rights. In an interview given to Eurogamer, the author dropped this iconic comment. They offered me a percentage of their profits. I said no. There will be no profit at all. Give me all my money right now. The whole amount. It was stupid. I was stupid enough to leave everything in their hands because I didn't believe in their success. But who could foresee their success? I couldn't. So, according to the information disclosed by media and by the publisher, in 2007, the author sold, so he assigned his IP rights for game projects. He gave them to the publisher because he did not want to participate in a revenue share structured agreement in which he would receive a part of the profits of the game. He wanted to receive everything at once. And as you can see, he bitterly regretted this negotiation, as we can see in his comment. However, the author understood that the agreement was not duly executed, and therefore he wanted to discuss it before the courts. Recently, parties settled in an agreement too, but just please guys see that even an assignment can become a problem if it's not clearly and well written. Finally, another aspect of just to point out, I don't know the terms of this agreement, so but I'm pretty sure that the author lawyers used different or their interpretation to claim that the agreement was not duly executed. And finally, another aspect of a publishing agreement that should always be considered by the parties is the credits. Even though the obligation to indicate the creator's name is usually a legal rule, it's interesting to establish how credits should be shown in the final project. For example, the logo of the studio should come up at the beginning of the game with a specific sound effect, and so on. Now we finally arrive at the most important part of the publishing agreements, the revenue sharing rules. Usually, parties are free to define the rules on how the money arising out of the game sales should be divided among them. However, there are some patterns in this market, some standards, I better say. In the indie game industry, agreements between game studios and publishers usually define a revenue sharing division between 50-50 and 80-20 in favor of developer. Such definition will vary according to several elements: the status of the project, the prestige of the game, the prestige of the studio, the team behind it, if there is money paid in advance, what activities are expected from each party, and among others. Usually, the higher the risk of the financing party, the higher will be its share in the revenue sharing structure. First it's always important to define what is understood as revenue for the purpose of the agreement. Usually, the sharing is defined over a net revenue amount, but never rely on external concepts to explain what is net revenue, because you will find anything one, especially in the internet. Put your definition in the contract. In most agreements, revenue is defined as the total amount of money received from the sales of project, less taxes and third-party commissions. Project and marketing expenses are also usually included in these expenses to be deducted. After the net revenue is calculated, money is then shared among the parties. In negotiations where publishers anticipate money to studios, it's quite usual to find clauses that label such payment as a recoverable advance or a recoupable amount, allowing publishers to receive 100% of project revenue until such disbursement is fully returned. In other cases, parties agree on a different division, more beneficial to publisher, until this early investment is fully recovered. After that, the division then migrates to the general rule of the agreement. Finally, a must-have clause in a publishing agreement is the developer's right to audit the publisher's books. In case any error is found and the studio is underpaid, publisher shall pay the difference plus interest. In some cases, we also see the application of a penalty fee, and for serious cases, a material breach for a forced termination of the agreement. Speaking of termination, every well-written agreement will have rules that regulate its termination. The purpose of an agreement is exactly to grant legal certainty and predictability for the business it regulates. Agreements do not make infallible relationships, but they give a path to follow when parties face a negative situation. Therefore, besides the natural expiration of a contract at the end of its term, parties may agree on an unilateral and unmotivated termination options, and if so, please consider establishing a prior notice and also a compensation depending on the side you are on. On the other hand, rules that cover infringement situations are extremely important for both parties. Usually, publishing agreements establish a division between minor breaches, like a 2-day delay to deliver something, which can trigger soft penalties like a fee, and material breaches, like the refusal to deliver the game or the refusal to promote commercialization activities, which therefore can cause the forced termination of the agreement, the payment of damages caused by the infringing party, the return of the money invested, some penalty fees, and so on. Something that I always suggest, based on the contractual good faith, is to define a remediation procedure. In other words, instead of an immediate termination, the innocent party should inform its partner about the infringement and ask for a solution within a reasonable time frame. If the problem is not solved, then a forced termination and its consequences will take place. Well, until now we have seen all the must-have clauses of a publishing agreement. However, as I warned you before, due to the versatility of this kind of agreement, you should also pay attention to some specific rules that might be important for your specific deal. Usually, publishing agreements will establish some kind of exclusivity. So pay attention to any exclusivity clauses in your agreement, especially in favor of the party that puts money in the operation. This exclusivity can be wide, so uh, it can include every possible commercialization of the game, its extensions, sequels, prequels, and ancillary projects, or it can be strict, only for a specific platform only for the game commercialization, and etc. Also, considering that the publishing agreement is usually designed for a project of common interest, sometimes you will find non-compete clauses written in that contract. And these clauses can usually work both ways. The game studio will commit not to develop a game in the same niche, for example, puzzle games, and the publisher will commit not to sell a game with similar aspects during the agreement term. Another clause that might show in your agreements are the preference rights. Sometimes, in order to award the publisher for believing and investing in a project, a publishing agreement might include a clause that defines that if further editions, continuations, sequels of the game are to be developed, the publisher will have a preference to be a part in that project. The last clause that might appear in your publishing agreement is a dispute resolution. In the end, a well-written agreement might not be enough if parties face difficulties to exercise the prescribed rights. In publishing agreements, which usually comprise several international elements, such as the parties, the place of sales, place of payment, it is highly recommended to define a national law that will govern the agreement and which court is deemed competent to receive any lawsuit arising out of the contract. Usually, the law of the court of the country of the publisher, the law and the court of the country of the publisher are the ones elected by the parties. An option that should always be considered in business like this is the election of arbitration procedures. Private entities that could receive and issue a binding decision to solve any dispute between the parties. For this to work, an arbitration clause must be included in the agreement. Well, as you have seen today, publishing agreements are contractual instruments with a wide application in the game industry, but nonetheless, you should always pay close attention to the core aspects of such agreement, since they can determine the project's future. And please, in case of any doubt, find a lawyer that can assist you. There are plenty of good professionals out there that really understand the dynamics of the games market. Thank you guys for the attention. Feel free to contact me and to send me your doubts if you have anything to ask. And see you there in Digital Dragons. Bye-bye.